Hi everyone. In the last class, we have discussed about the specific portions of the Transfer of the Property Act, in which we have discussed about the rights and the liabilities of the buyer and the seller that we have discussed in details. Okay. So from the upcoming sections, we are supposed to discuss the from section 56 onwards, which were dealing with the concept of the marshalling by the subsequent purchaser, right? So coming to the part in which we have discussed already about the part of the selling and the buying, in which we have discussed, there are the basic concept of the sale. So when we are talking about what is sale, then we have understood that sale is the basic transfer of the ownership in exchange of a price paid or promised, or partly paid or partly promised. Under this, we have already discussed that, for example, I am giving you something, and in exchange, you are paying me a certain amount of the consideration as a money or something like that, right? So, when I am getting in return something in exchange of something, that is called the concept of the sale. Sale is the basically the transfer of the ownership in which you are transferring the ownership of the property to some other person, right? And sale is the transfer of ownership in exchange of the price paid or promised, or partly paid or partly promised, right? So when you are talking about the transfer of the ownership of the sale, in which it is not always mandatory that you have to pay the like the full price of the thing in exchange of the ownership. No, you don't have to, right? That means when we are talking about the transfer of the ownership, the price can be paid in a fully manner, or the price can be paid in a partly manner, right? So the price can be paid or promised, or partly paid or partly promised. For example, there is a watch I am buying from the shop, and the actual price of the watch, that is up to the amount of 5,000 of the rupees, right? So I have my right to pay the shopkeeper up to the amount of 2,000 of the rupees, and I'll promise the shopkeeper that I'm going to pay the rest amount of 3,000 rupees in a later phase to the shopkeeper. You are taking a car on the EMI. The car that is costing up to the amount of 30 lakh, 40 lakh, up to the amount. Sometimes you are paying the full amount of the car, or sometimes you are paying the half price, or you are taking it as an EMI. So in EMI, you are doing the partial payment of the property, where you are just balancing your resources. Like, for example, you are paying a certain amount in a monthly basis. There is a divisible factor on this. Like, per month, you have to pay this much amount, right? So accordingly, you have to pay the amount of 20,000, 5,000, 15,000, whatever the amount of the EMI is, in a monthly basis. You have to pay it. So this is the concept of the part payment, in which we know that we have to pay for it, but we don't have to pay for the same thing in a one time or one day, but we can pay it on a gradual basis or day to day basis, right? And the second concept is promised or partly promised. I have bought a watch from your shop. So either I am promising you that yes, I am going to give you the full amount by the 10th of the January. So here I am promising that I am going to pay you the full amount on this specific day. Or the second condition, I am doing the part promise of this. For example, I am promising you the first half of the money I am going to give you on 10th of the January, and the second half of the money I am going to give you on 20th of the January. This is my promise over here, and this is called the part promise, in which I am doing my promise on a partly basis. This is called the concept of the part promised. So either I am promising I have to give the full amount of the money, or I am doing the partly promise that, for example, this half I have given you the 2000 of the rupees, and the rest amount of the rupees I will pay you on the another day, or another next month. So this is called the concept of the part payment, where the sale is the transfer of the ownership in exchange for a price paid or promised, or either it is partly paid or it is partly promised, right? So when we're talking about that sale how made, in which we have already discussed that the property is the tangible immovable property, or in case of the reversion or other intangible thing, where the value of the property is more than 100 rupees, it must need to be registered. And when it is below 100 rupees, it can done either by registered instrument, but it is not mandatory to do the registration. In case it cannot be registered, it can be delivered by some other way, like the delivery of the property. For example, we are going to any kind of the shop, we are buying certain instruments from the shop, and in the specific shop I am paying the shopkeeper 500 of the rupees, and in exchange he is he is delivering me the certain amount of the goods. So this is called the delivery of the property, where there is a mutual understanding that this kind of the sale doesn't need to be done with any kind of the registered instrument, because here this is pretty clear that the amount of the price we are paying for the specific goods, and we are getting that with the right price, so there is no point, there is no need to do the registration. But when you are going to any kind of the big malls where they have to put the accounts, the calculations, you must have seen that they are putting the bills. Even if you buy a very small thing that is up to the amount of 50 rupees, then also at their place you have to make a bill on that. So that is called the registered instrument, where you have to do your registration of the document, where you have to certify your buying of the thing, right? And the last point, contract of the sale. A contract of the sale of the immovable property is a contract that a sale of the such property shall takes place in terms settled between the parties. That means if there are any kind of the certain terms and the conditions that is been fixed by the parties, for example, we are entering into an agreement that you are going to sell me your watch and I'm going to buy it. So here there are certain terms and conditions that has been associated, that the watch is going to be given, or the watch is going to be sold the relatable lower price than the buying price. For example, you have bought it at the price of 10,000 of the rupees. You used it for the duration of 1 year, and then you are selling it to me with the amount of 5,000 of the rupees, with the half price. So there is the mutual understanding. There is a mutual contract of the sale between the seller and the buyer, right? That according to the terms and conditions of the contract, the things will happen, right? So there is a agreement, mutual understanding between the parties that this is the amount that need to be paid. And rather, after a particular phase, neither the seller nor the buyer, no one can raise any question on it, because it is very clear. Rather, on a later stage, you cannot raise a question on it, because this is the thing that has been primarily decided and settled down between the parties. That has been fixed earlier. You cannot change it, right? So this is the primary concept of the cell we have discussed. Then the section 55, it speaks about the how the cell is being like what are the rights and the liabilities of the seller and the buyer, that we have already discussed in the last class. Then comes section 56, which speaks about the marshalling by the subsequent purchaser, right? So what does it speak? If the owner of two or more properties mortgages them to one person and then sells one or more of the properties to another person, the buyer is, in the absence of the contract to the contrary, entitled to have the mortgaged debt satisfied out of the property or properties not sold to him, so far as the same will extend, but not so as to prejudice the rights of the mortgagee or persons claiming under him or any of the person who has consideration acquired an interest in any of the properties, right? So let me make you understand. Okay. So what do we understand by the mortgage? So when we ask you that what is mortgage? In that specific case, we say that the mortgage is a transfer of the, when I am keeping anything near you in exchange of a specific value, that is called the mortgage. For example, I need the debt that is up to 30,000 of the rupees, and in return I have nothing. So I am giving this golden ring near you that just keep it, and in return just pay me the 30,000 of the rupees. I am keeping my ring as a mortgage near you, and I promise that I am going to pay back to you in between the duration of 6 months. If I'm unable to pay you the 30,000 of the rupees in the duration of the 6 month, then you can sell this ring and recover your price. So this is called mortgage. When you need a debt, or you are giving something to someone in exchange of something which you have to pay later or recover on a later phase, right? So when we're talking about section 56, which speaks about the marshalling by the subsequent purchaser, then we have to understand that when there is the mortgaged property, okay, for example, I am having four lands altogether, right? There are four different places of mine in which I am the owner of four different lands, okay. So what happens that when I am the owner of the four different lands, I am using those lands for the, kind of the business purpose or some other things. Then I have to collect a debt from the specific other person. Okay. So when I accept the debt up to a certain amount from a specific person, then I have to put my land as a mortgage, because to recover the debt or to put something in exchange of the money, I had nothing, right? So hereby I have to keep my own land as a concept of the mortgage. So when we are talking about the mortgaged debt, that means any kind of the debt that is given, any kind of the debt that has been brought in exchange of a mortgage, that is called the mortgaged debt. Okay. For example, uh, I am having a land of mine and I am giving my land as a mortgage to you for the duration of 1 year. And I promise you that I promise you that I am going to compensate the whole amount of this much in the in duration of the 1 year only. But if in between the time period of 1 year I am unable to pay the debt, then you have all the right to sell the land and take the benefit from the sale, right? So here when we are talking about the subsequent purchaser, The person who buys the property on a later phase is called a subsequent purchaser, right? For example, I have bought a land. Got it? And I am the owner of the four different lands at different places, right? So I have the ownership on four different lands altogether. So when I need a specific amount of the money, I have to compensate it, and that is why I have to put the mortgage up to different lands. Got it? So what do we do? We did like when we're talking about the mortgage, we have like the person. For example, I'm having four different lands, and among those four different lands, I have put two lands as a mortgage. Okay, so I was supposed to like recover the loans of those lands because I have taken the loan up to a certain amount from those people or those mortgagee. So here I have put my land, two different lands, as a mortgaged debt. Okay. So after that, what I did, the lands which I have put as a mortgage, then I decided to sell the land. So what did I do? I went, I decided it, and then I sold the land. Okay. So when I sold the same land that I have given as a mortgage, the debt, the mortgaged debt that was supposed to be satisfied from the mortgaged property, what will be the circumstances on that? How those amount is going to be recovered? The answer is very simple. If we are looking forward that yes, the mortgage debt was recovering from the specific amount of the mortgage property and the property is being sold, then there is no point to worry. If the owner has any other property similar to that, then the mortgage debt can be recovered from that in a very sweet way, right? So this is the concept of the marshalling by the subsequent purchaser. Who is the subsequent purchaser? The primary person is the mortgagee who has taken the mortgage of the land. The subsequent purchaser is the person who has who has subsequently taken the loan. Sorry, who has subsequently purchased the land. The person who has purchased the same land which has been given as the mortgage is also called as the subsequent purchaser. Okay. So when there is a subsequent purchaser, he presents, he can ask the mortgager to pay the mortgaged debt from any other property of him, as he is the original owner of the property. Then after the transfer, so he can enjoy his rights in a very peaceful manner. Who? The buyer, I mean. Who is the seller? The person who is the mortgager is the seller, and the person who is a buyer, he is other than a person who is a mortgagee. The same property has been given as a mortgage, as well as the same property has been sold out. So if the owner has any kind of the specific circumstances in the situation that the other person who is claiming under him, who considered interest in the property, this is the primary motto of this section, that to prejudice the right of the mortgagee or the persons claiming under him. To prejudice the right of the person which claiming under him to get the mortgagee, right? And who has the consideration acquired in interest in any other properties, right? So hereby, when we are talking about the marshalling by the subsequent partner, then the subsequent partner can come and say to the original partner that yes, the subsequent partner can come and say the original partner that here, as I have already bought the property, this is not my responsibility to recover the debt from my property anyhow. Now it is your responsibility and you can take care of the other debts from the other properties that the person specifically belongs, right? So, section 57, it speaks about the provision by court for encumbrances and sale freed therefrom. Okay, so this is the last section that is belongs to the part of the sale of the property, and that section is section 57, which speaks about the provision by court for encumbrances and sale of the freed item. And in the previous section, I think we are clear about it. We have clearly understood that when there is the same property that has been mortgaged and that has been sold out, then the person who has brought the property, he should not be affected due to the uh, carelessness of the mortgager. Like if the mortgager, even after knowing this, he is doing the same thing. So here it is not even after knowing the mortgagor is selling the same property to any other person other than the mortgagee, then the right of the mortgagee and the right of the buyer, it is not going to be hampered, because the person who has the mortgagee, he has the right to get a specific amount on a monthly basis or on a dealing basis, right? And the person who is the buyer, he has bought the property with a good faith that he is the owner of the property. So here the mortgager and the mortgagee has the right to recover the compensation that the mortgagee is entitled to do, and the buyer has also right to enjoy the property which he has, right? So hereby, whenever we are talking about the marshalling by the subsequent purchaser, then in that specific circumstances we have to understand that when we are talking about the marshalling by a subsequent purchaser, any other person, any other secondary person other than the mortgagee, then in that specific circumstances, the mortgagee can ask the mortgager to recover the mortgaged debt from other properties of him. उसका अगर दूसरा कोई प्रॉपर्टी है, the mortgage, the subsequent the subsequent buyer may ask the person to do that. The person who is the owner of the property, who is the who is the secondary person who bought the property, he has right to enjoy the property peacefully and it should not be disturbed. Got it? Then it speaks about section 20. It speaks about section 57, right? Coming to the next section, that is the last section of the cells, the concept of the cell. It is the section 57, which speaks about the primary concept of the provision by court for encumbrances and sale from the freed therefrom. Okay, got it? So it is primarily speaking that when the property This appears to an except outlying legal procedure related to sale of the immovable property. And uh, when the property with encumbrances is sold, the court can direct or allow payment into its property, right? And the second point is when the property with encumbrances is sold, the court can direct or allow payments into the custody, right? So, when we're talking about the payment into the court, then we have to understood that the property with encumbrances is once sold, the court can direct or allow payments into its own custody. Got it? Then, for annual or monthly charges or capital sums based on the discriminable interest, a sufficient amount must be invested in government securities to maintain the encumbrance through the generated interest. Got it? So, when we are talking about the payment into the court, then we have to understand that the property with encumbrances is sold. Okay, right? The court can direct or allow payments into its custody. Got it? For example, there was a property which had the encumbrances up to the 30,000 rupees. It has been sold now. So there is the right of the court who can direct or allow the payments into its custody. The court can directly ask the person to do the person directly instead of paying anybody else. The payment can be done to the specific person who has bought the property in a well manner, right? So when you're talking about the payment into the court, it exactly speaks that when property with encumbrances is sold, the court can allow payments into the custody for annual or monthly charges or capital sums based on based on the determinable interest, and a sufficient amount must be invested in government securities to maintain the embrace through the generated interest, right? That means, so when we are talking about the property which uh, encumbrances is sold, right? The court can direct to allow payments into its custody. Here, the court can say, instead of paying the payment at any other place, you do the payment at my place. You have to do the payment in between the custody of the court. That is most important, right? And for the annual or monthly charges or capital sums based on the determinable interest, a sufficient amount must have given a sufficient amount must have been given, and the most important part is when her annual or monthly charges or capitals, the sums is based on the determinable interest. The sufficient amount must be invested in government securities to maintain the encumbrance through the generated interest, right? Then comes the second point. It speaks that for the capital sums, the payment must be sufficient to meet the encumbrance and the related interest, right? So when there is the payment at the court of law, right? At that specific place, when we are talking about the capital sum, the whole sum, at that moment, the payment must be sufficient to meet the encumbrance and the related interest. Here, the payment must be sufficient, must be done to meet the encumbrances, to meet the uh, uh, left out payments. and the related interest. Got it? Then the second point is about the related interest, a related amount or additional amount, right? So what does it mean? An extra amount up to 100% of the initial payment may be acquired cover potential uh, contingencies. Example, the cost, expenses, interest, make interest, and it accept the depreciation. The larger additional amount may be directed to a special regions that is recorded by the court of law. Okay. Then the third point, it speaks about the declaration of the property as fee from the encumbrance, right? The court, after notice to the encumbrancer or the person who is dispersing, who is dispensing or designing with notice for the specific regions, may the first thing is to declare the property free from the court. Then the second point is the order necessarily conveyance or vesting to give the effect to the sale. And the third point is the direct retention and investment of deposition money. So there are three conditions in which the court, after notice of the encumbrancer, may the first thing declare the property free from encumbrance. The court can show some pity and say that no, I'm not going to put this property on encumbrance. So I'm just keeping this property free from all kind of the encumbrances. This is the first thing the court can do. Or on the second concept, order necessary conveyance or uh, order the necessary conveyance and visiting to give to effect the sale. Okay. And the third parties, the third most important point is direct relation and investment of the deposited money, direct retention or investment in the deposited money. Okay. Then distribution of the funds after serving the notice to the initial parties. After serving the notice to the initial parties, the court may, the first thing what the court can do, order the payment or transfer of the deposited money to the entitled person, provide directions regard direction regarding the distribution or application of the fund. Then comes the concept of the appeal. Then in the appeals, any kind of the decision, if it is seen that the decision is appealable in nature, जो भी डिसीजन दिया गया है उसी को अपील किया जा सकता है एंड इस सिचुएशन पे अपील करना जरूरी है, then in that specific circumstances any declaration, order or direction under this specific section is appealable and is back to the degree. Got it? Then under section 6 we have discussed about the definition of the court, in which we have understood the court. The term court, it refers to the first point, the high court with original civil jurisdiction. The second point, the district courts, the district courts court. Okay. Uh, the high court with original civil jurisdiction. The district judges court with jurisdiction over the property's location, right? So the definition of the court that belongs to the High Court first. The second to the district judge's court and jurisdiction over the property's location. Either the district judge, if he is putting any jurisdiction on a specific property, right? So the district judge's court, if he is having any jurisdiction over the property's location, that will be considered as a court, right? And the third point is the distance and the third point is any other court declared the company by state government through through the state governments, okay, through similar or applicable to a decree. Got it? So the point of the definition of the court, it basically indicated three different courts. First, the High Court. Second, the District Judges Court. And the third, the other court that declared completely the state government through a specific notification. Right? So, this is all about section 50. This is all about the section 58. And under this, we have discussed what is the appeal, what are the definition of the court, in which we have understood the court is basically of three types, that might be the High Court, might be the District Court, and at the end it might be any other specific local court. Okay, any other court declared competent by the state government through a notification. For example, there is the Court of the Junior Division, Court of the CJM, Chief Judicial Magistrate, Court of the Judicial JMFC, Judicial Magistrate First Class, JMSC, Judicial Magistrate Second Class. So their courts are also recognized by the state government. So here the state government can, through a notification, declare a specific court to be inaugurated or running, and the person can continue on that manner thereon. Got it? So this is the definition of the court that we have discussed. So along with this, we completed the provision of section 57. In the next class, we are going to discuss the concept of the mortgage, which is explained under section 58 of the Indian TP Act. So this is all for today, guys. Thank you.